Well, the other thing that happens during a prelim is the right to admit or deny the allegations, the right to seek placements, which will automatically really be addressed by the entrance of the plea and the proposed arrangement. Do you know of any other guardianship or custody or even juvenile delinquency proceedings that would concern your daughter?
No, not that I know of right now.
Not at this point.
Okay. Do either of you have any reason to believe you have Native American heritage in your family?
No.
No, Your Honor.
All right.
At least nothing proven.
All right. All right, well, as it relates to the no contest plea then, would you agree, Ms. Thomas, to that request?
Yes, Your Honor.
Ms. Heiss, what are your
Yes.
thoughts?
Yes, I believe there is potential criminal liability, and it isn't necessary for us to have a guilty plea to get this family into services. I think no contest is appropriate.
Thank you. All right, Mr. and Ms. Lewis, a no contest plea essentially means that you don't have to affirmatively tell me that you are responsible for any of these things, but I will basically take each and every allegation of the petition and assume that it's true. Do you understand that?
Yes.
Clarification, Your Honor. My client has advised me that on her husband's side of the family, they've been informed that they have Cherokee blood from Southeast United States. They haven't verified that. I think we still probably have to explore that if it's been brought to my attention.
Okay, Ms. Harvey, I know that this is not the first time we've interacted with this family, so if you could check and see if that heritage search has been done,
Yes.
or of course resubmit it as necessary.
Narrow it down
Yeah.
just to the track.
Cherokee.
Yeah, I'll check and see just the Cherokee. If we've done it before, I'll check.
Thank you. All right, very good. Okay, Mr. Lewis, did you hear my comment about the no contest plea?
Yes, Your Honor.
All right. Well, if I accept your plea, Mr. and Ms. Lewis, you are giving up your right to a trial by judge or trial by jury, the right to have the petitioner prove the allegations in the petition by a preponderance of the evidence, the right to have witnesses against you appear and testify under oath, the right to cross-examine those witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. You understand you'll be giving up or waiving the rights I just indicated to you if you enter your no contest plea, Ms. Lewis.
Yes.
Mr. Lewis.
Yes, Your Honor.
With regard to the consequences of your plea, or in other words, what will happen, court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there is no need for the court to be involved. If it appears that there is a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home and order counseling or other programs for you and your child, such as drug and alcohol treatment, assessments, or parenting classes. If it appears that you will not be able to provide a proper home for the children in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea, Ms. Lewis?
Yes.
Mr. Lewis?
Yeah.
Do you have any questions about any of the information that we've gone over so far, Ms. Lewis?
No.
Mr. Lewis?
No, Your Honor.
All right, is anyone making you enter a no contest plea, Ms. Lewis?
No.
Mr. Lewis?
No.
Has anyone threatened you in order to get you to enter a no contest plea?
No.
No.
Outside the terms of the plea agreement, which I think are essentially just the fact that it's gonna be no contest, has anyone promised you anything in order to get you to enter a no contest plea?
No.
No.
Would you, are you under the influence of drugs, alcohol, or anything else that could get in the way of you understanding what you're doing this morning?
No.
Would you say your decision to enter a no contest plea is one you've made of your own free will?
Yes.
Yeah. Yeah.
Okay. As it relates to the factual basis of the plea, Ms. Thomas?
Thank you, Your Honor. If Ms. Harvey can be sworn in to provide that.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Full name one more time.
Sarah Harvey.
Ms. Thomas?
Thank you. Ms. Harvey, today the parents would like to enter a no contest plea. And in part of that, there needs to be a factual basis for their plea. How are you involved in this matter?
I'm the CPS investigator.
And do you believe that as the investigator, you have sufficient knowledge as to the facts that are, or the allegations that are contained in the petition?
Yes,
And you in fact drafted the petition, correct?
correct.
What, during your investigation, what were the concerns that led you to file this petition?
The original allegation came in with allegations of sexual exploitation by an adult sibling of PL. There were also concerns about marijuana usage in the home at that time.
And what investigatory process did you use or undertake to ascertain whether those were valid concerns?
Initially, an on-call worker did interviews alongside an officer from Madison Township. At that time, the adult sibling indicated that he had been in a bathroom in a hotel where PL and LS were staying for the day. They would go to work with PL's mom. Then they would go swimming at the hotel and kind of hang out in the hotel room. He indicated that he had been in the bathroom making videos and had left his phone in the bathroom recording. PL and LS then entered the bathroom without knowledge that the phone was recording and undressed and took a shower together. That was the initial interview. We did do a CAC then as a follow-up. At that CAC, both LS and PL indicated that this was not the first time that they had been recorded by the adult sibling. That a year ago, they had found a phone put in a windowsill, kind of half behind a curtain, that was recording them inside PL's bedroom. They also, PL indicated that at one point when they were younger, the same adult sibling, now adult sibling, had attempted to touch her breast.
The investigator further revealed that the child had previously been removed years earlier due to separate supervision concerns involving abuse by another individual.
And she had at each time taken this information to her parents, and she felt that her parents did not have a response to the situation. No safety barriers were put in place at that time. We also did look into the allegation of marijuana in the home. While the parents have use of marijuana, it wasn't an indication that they were providing marijuana to PL at that time.
Thank you. And during your investigation, was there any indication that the parents believed PL and what her brother was doing?
We did have a family team meeting where both Mr. and Mrs. Lewis expressed some concerns that PL may not have been truthful in her response. We did tell them what the adult sibling had told the officer. And they were also, at that time, the adult sibling made some threats that could be heard by workers because we were on a Zoom FaceTime. He made some threats to her, which heightened the concern for PL's safety with the adult sibling in the home.
Were the parents immediately agreeable to removing the adult sibling from the home?
No, they reported that they did not have a place for him to go. There was no appropriate family member where he could stay, and there was also no appropriate family member or friend for PL to go to.
And
they reported
they
reported that the safety plan that they had in place was that the adult sibling no longer had a phone because the police had that phone, so they thought that she would be safe.
And has PL been removed from the home in the past due to concerns of improper supervision or failure to protect against another I guess, individual.
Yes, in 2019. Yeah, in 2019, she was removed from her home for improper supervision, which resulted in sexual abuse by a third party.
Thank you. Your Honor, for purposes of factual basis, I have no further questions of Ms. Harvey.
Gentlemen,
Just one. What's the current status? Is there a current active investigation by the Madison Township Police?
Madison Township Police had to turn over the investigation into Maumee, Ohio Police, because it was a jurisdictional issue. This did take place in Ohio. As far as I know, at that point, they're still investigating.
Could you keep us up to date on that?
Yes.
Nothing further.
any questions, Mr. Brooks?
No, Your Honor.
Ms. Heiss?
Ms. Harvey, the agency's recommending at this point placement of the older boy out of the house, leaving the child in home jurisdiction. Is that correct?
Correct.
So the ongoing service person will put in a safety plan. I assume that will address we don't want contact between these siblings that's unhealthy, but we don't want no contact if it can be supervised. I don't know the nature of their relationship, but we'll address that, correct?
Yes.
Can we also safety plan no unrelated adults in the home for the time being, just to protect? It seems to be a issue from the last case.
Yes, we can put that in the safety plan.
Can we be sure that the parents are compliant with any medication as prescribed? I don't know yet, but will we be checking on that?
Yes, Peyton will need numerous services started and put in place, and all of that will be monitored by the ongoing worker.
Okay, and the last thing is, are you willing, in 2022, this child was on juvenile probation or for some vandalism type thing. Would you be willing to partner and maybe have the probation officer join an FTM so we can hear what services they provided and what was successful and learn from their case?
Yes, yeah, we can do
Okay.
that.
Thank you. I have nothing further.
All right. Are the attorneys satisfied with the factual basis of the plea and the advice of rights?
I am.
I am, but I do have a follow-up question.
Okay, one moment. Ms. Thomas, Ms. Heiss,
Yes.
Your Honor.
go ahead with your question.
My understanding is the 16-year-old minor, she's now 16, correct?
Correct,
She does have a boyfriend.
correct.
She may wish to have contact with him, so if we have no adult in the house.
Correct. We will put that in, we'll address it in the safety
I
plan.
do have,
Hang on.
sorry.
Okay, so you're not saying that she can't have contact with her boyfriend, but just in a supervised setting?
Yes, correct.
Thank you.
Thank you for your testimony. We return to proceed. All right, the court is satisfied that the plea is knowingly, understandably, and voluntarily made. I further find the record supports one or more of the statutory grounds alleged in the petition are true. Ms. Harvey has detailed the issues in the home as it relates to the factual basis of the plea that also constitute the actions that do violate MCL 712A.2b, which indicates in this particular case under sections 1 and 2, there has been a violation as it relates to the parents failing to protect, and the language of the statute really specifically indicates the child's parents, when able to do so, neglects or refuses to provide care necessary for the child's health or morals, who is subject to a risk of harm to her mental well-being, which has been clearly established by the testimony of Ms. Harvey. Secondly, that the child's home or environment with her parents by reason of that neglect or depravity on the parent's part is an unfit place for the juvenile to live in. I also find that that's been met as a result of the victimization of this child in the home on a sexual basis, and the failure of the parents to intervene and protect her from the same. Go with the order of the court that Mason Lewis is ordered out of the home, in addition to the court's jurisdiction over both parents and the child. We'll count on the department to continue to look for resources for the family and for the 16-year-old, and begin all of the referrals for the family, whether that's CMH or ACPC. I'm sure that this child is going to need some support around her mental, physical health, emotional health. So we'll look for all updates on all of that in our initial disposition, which is our next court hearing. Between now and when we come back, the department will meet with you, Mr. and Ms. Lewis, to put together a plan to set some goals and a course of action. And this course will then monitor on a semi-regular basis, at least every 3 months. And hopefully you'll reach those goals and you won't have to have the interference of the court in the future. For our next court date, that's within 28 days. And I have some time available at 11 a.m. on Friday the 23rd, if everyone's available.
February 20.
A major ruling followed immediately. The older sibling was ordered out of the home, while the child remained under in-home court jurisdiction.
Third, Your Honor.
Yes, at 11 a.m.
Judge, I have that we had
Have you
a
already filled-
review. Yeah,
Well, I know we just did the. Okay, all right. Well, let me go look.
but it looked in my calendar, I also have that set for 9, so I'm not sure what happened
Which
there.
one?
Miller,
Which-
there's a 9 and 11 in my calendar. I don't know, Lee, what you have.
I just have 9.
Okay. My
I just have
calendar's
9, but
I'll tell you. It's fine.
We're figuring.
So
it out.
11. I think 11 is clear. If it doesn't work, then we'll find some time another day, but I think 11 a.m. on Friday the 23rd does appear to be open at this point. I have been known to double book occasionally, but if we figure out that that's a problem, we'll let you know as soon as possible. So we'll be back for disposition February 23rd at 11 a.m. The child is in the home that is the safest and least restrictive at this time, allowing that her older brother will not be residing there, at least for the time being. And we'll be working, the department will be working with the family to continue to work on safety and boundaries in the home. Understanding too, the court is still looking for opportunities for the child as well, to potentially stay in another residence. Okay. All right, any questions? All right, I'll have the order ready for you in just a few.
I think that's fair to say. He's been the employee of the month at Goodwill more times than I could count, the employee of the year several times. He frequently calls up Dale Gardner and speaks with Dale on the radio. Yeah, Roger's, he's a gadabout.
Excellent. All right, well, is all of the information in your accounting truthful, accurate, and complete?
Yes, sir.
Very good. Any questions or issues on any of those things, Mr. McFarland?
I found no issue. I signed the waiver and consent draft.
Yep, the 18th and 19th are in there. All right, if you're joining us by Zoom, please make sure your device is muted. There we go. I'll have to help you unmute with that later. Very good. All right, well, the court finds all interested parties were given notice for purposes of the hearing on the 18th, 19th, and 20th and counting. In this case, the information does appear to be correct. Ought to be allowed has been reviewed by our guardian ad litem as well. So the order is approved. The accountings are approved. Thank you, Mr. Shadler. Unless there's any questions, that's all for today.
Thank you, Your Honor. Have a great day, great week, and a Merry Christmas if I don't see you before.
Thank you. Tell Roger I said hello.
I will. Mr. McFarland, thank you for your help.
This is on the matter of the estate of Roxanne Steve, file 53414DE.
This one's been docketed as a request to open a probate estate. May I have the names of our participants, please?
That is correct, Your Honor. Attorney Ashley Hanson Grimes on behalf of proposed personal representative and sibling of Miss Steve, Jean William Corkle, who is joining us via Zoom.
Good morning.
Along with several of the other siblings, I believe, as well.
Yes, all right. So, yes, I see they're logged in under Jean Corkle. Can you hear us okay?
Yes, I can.
All right, good morning. Could we have your name for the record?
Jean William Corkle.
Thank you. Looks like we have another Corkle logged in. JW?
Yes, Jeremy William Corkle. I'm a brother.
Good morning. All right. Is that everyone you were anticipating for today?
It was, Your Honor. There are several other siblings, but I'll get to that. Miss Roxanne Marie Steve passed away on or about September 16th, 2024, here, a resident of Lenawee County in Adrian Township. She was not survived by a spouse, nor did she have any children. Her heirs are her siblings, Susan Ann Waldvogel, Jean William Corkle, Randy William Corkle, Jeremy William Corkle, and Katie Elgin Corkle, all who have been notified of the proceedings. My client, Jean William Corkle, has decided to assist in being the personal representative of the estate because there are items that do need to go through probate, including a home located here in Lenawee County. So we ask that you determine her heirs as I have described. You determine that she was a resident of this county for purposes of probate being proper here, and that she did die intestate as her death was unexpected.
Thank you. The court finds that they filed to support all of the elocution made by Ms. Hanson-Grimes this morning. There is a certificate indicating that Ms. Roxanne Steve did in fact pass away September 16th, 2024, a resident of Lenawee County, making venue appropriate in Lenawee County Probate Court. The decedent's heirs are outlined in the proposed order of formal proceedings, slightly phrased slightly differently than how you phrased them here this morning, Ms. Hanson-Grimes. But I did recognize all of the names, and that's also an uncontested assertion, as is the one that Ms. Steve passed away without a will. Mr. Jean Corkle is suitable for the appointment. I do not find supervised administration to be necessary at this time. And clearly all of the heirs are invested, and it sounds like there are some assets, but not necessarily liquid assets that would require a bond at this time. It is the order of the court. The petition is granted. The findings are reflected also that Ms. Steve passed away intestate. The appointment of Jean Corkle is also contained in the order as personal representative without bond, and of course the determination of heirs. I'm also signing the letters of authority. It will give Jean Corkle what he needs in order to administer the estate, obviously with the assistance of his attorney, or the attorney for the estate. Thank you all for coming and for your patience this morning, and I'm very sorry for your loss.
Thank you.
All right, Ms. Hanson-Grimes, if you'd like to, I don't know if you have any more today, but you're welcome to step across the hall to grab copies of this if you want.
I will. I do have one more.
Which one do you have?
It would be the estate of Shirley Hampton.
Oh, that's next anyway.
This is on the matter of the estate of Shirley Hampton, file 53407DE.
All right.
May I approach just for a second?
Sure, one moment, please.
The hearing reflected the court's ongoing role in protecting vulnerable individuals, while ensuring guardians and fiduciaries remain accountable for every financial decision.
All right, Ms. Hanson-Grimes. Ms. Goodrich, you ready?
Yeah, I called it, yeah.
Perfect. All right, for the record.
Your Honor, this is a matter of Shirley Hampton, a deceased person who was a resident of Lenawee County at the time of her death on October 5th of 2023. I represent the estate, and Karen Muir, who does have priority as a fiduciary for Ms. Hampton, and the contents of her estate would be from the conservator estate, which was managed by Ms. Karen Muir. It has been brought to my attention that there are possibly two heirs, which would be Ms. Hampton's daughter, Whitney Cool, and a son, Michael Shores. Michael Shores, is new to my relationship with the case and has provided me a copy of, or a scan of a birth certificate, which does indicate Shirley Johnson being his mother, which is the maiden name of Shirley Hampton, as I am aware. I would just ask that the court, for purposes of heir determination, as Ms. Hampton had several files with this court, and that information was unknown to us throughout the last 5 years, just that paper copies be presented to my office for filing with the court of a current verified copy of birth certificate. Those are easily found on VitaCheck and can be provided to us, and only for purposes of the fact that during the guardian and conservatorship file, he was not provided notice of our proceedings because his identity was unknown to us. So we want to make sure that he is entitled to everything that an heir would entitle himself to, but we also need to make a proper record, as third-party liability may be involved in this case as well, due to her receiving services through the state of Michigan. So if Your Honor also agrees that that would be appropriate, just for coordination of all case files, as it relates to Ms. Hampton, including the conservatorship, the guardianship, and now the deceased estate files, I would ask that you do order that. And that we can move forward from there. She was a resident of this county, as I previously stated. She did die intestate, and the contents of the conservator estate, which is on or around over $30,000, does make it appropriate for this court to determine that venue is proper, and that we are in need of an estate so that Ms. Muir's case or conservatorship estate may be closed, and that the funds may be turned over into a probate estate and distributed upon her heirs, or through third-party liability if they should, or any other creditors choose to make a claim within this 4-month period.
All right. Do we have Whitney Cool or Michael Shores with us here today?
I did provide notice to Ms. Cool. I did, because I did have an address for her. I did email a copy of the Zoom instructions to Mr. Shores. I did ask him for his address for future notification purposes, but I have not received that yet. I did also email him a copy of the petition, as he had contacted my office last Friday, or before the holiday, so last Wednesday. So he was not given 14 days notice, but he is aware of today's proceedings, as he was aware of them when he contacted me, and has also been emailed through an email that he had reached out with that I do know went directly to him. So neither one of them are present, and neither one of them had any objections to Ms. Muir being appointed the personal representative of their mother's estate.
We do have a person logged in under a phone number ending in 7933. If you would please identify yourself.
Karen Muir, Your Honor.
Good morning, Ms. Muir. How are you?
Good morning. Good, thank you.
All right, Ms. Muir, have you talked with Whitney Cool or Michael Shores?
Yes. Just Whitney I spoke to through text.
Just out of curiosity, frankly, does she claim having a brother?
Actually, she never mentioned a brother until she texted me and she said, "My brother told me." And that was the first I ever heard of a brother.
Interesting.
I will state that Ms. Hampton's obituary does list Michael Shores, and that was something authored by the family, certainly. But this is also given my relationship and given the relationship that Ms.
Although the accounting itself had been filed, itemized receipts and additional records needed to verify specific expenditures had not been submitted.
Muir had with Ms. Hampton, why we seek to make sure that the files contain all information for the court to have, which would include verified copies and certified copies of current birth certificates.
I understand.
So
why you're asking. Also, is there, and maybe this is a better question for you, Ms. Muir, is there going to be potentially a request from the state of Michigan for repayment of some of the benefits that Ms. Steve
Yeah.
received? Is that a risk?
Yes, yes, there
Okay.
will be.
Very good. Do you know what that is by any chance, the amount of that?
Unfortunately, no, not at this time.
So,
Well, hang on one second. Ms. Muir, have you ever been asked to secure a bond for any of your cases or services as a fiduciary?
Yes, and I am bonded for $200,000.
Very good. Would you be able to secure a bond in this case? I think that may be the safest way to ensure that the funds are not scrutinized too closely by the state of Michigan, as well as the fact that it sounds like they're liquid and disposable. And obviously you're responsible for them anyway, but would you mind getting a bond on this?
Not at all. I can do that.
All right. Anything else for the record, Ms. Hanson-Grimes?
no, Your Honor, and I just want the record to reflect that the scrutiny that I am asking for is solely because the decedent did receive services from the state of Michigan, and I'm trying to anticipate questions that they may have going forward. Not that I haven't had the pleasure of working with both of the children, and that they have been forthcoming with information, and they were the ones who reached out to me. So it's strictly for the matter that we do think that third-party liability will be involved, and they tend to ask questions that I like to get ahead of.
I appreciate that. Court finds all interested parties are given notice for purposes of today's hearing. I have not had any objection to the determination of errors or the information that Ms. Hampton provided, or Ms. Hampton was a resident of Lenawee County at the time of her passing on October 5th, 2023. I also have no objections to the findings that she passed away without a will, or for the appointment of Ms. Muir, who does have priority since she served as the conservator for Ms. Hampton during the time she was with us. I do not find supervised administration to be necessary at this time, but I will take Ms. Muir up on her offer to secure a bond to protect in the amount of protect the funds estimated around 30,000. Is that what I understood, Ms. Hanson-Grimes?
On or about it.
Okay.
Ms. Muir would have a more accurate figure, certainly.
All right, so we'll leave that to you, Ms. Muir, to provide, and if we need to modify our order in that amount, just let me know. I'm happy to do that. Otherwise, the petition is granted and the findings are contained in the order as articulated this morning. I've also indicated the errors listed in paragraph 5, which are Whitney Cool and Michael Shores, are to provide certified copies of their birth certificates. Sign the letters of authority, allowing Ms. Muir to accomplish her obligations as fiduciary. And unless there's any questions, that's all for this morning, and I'm sorry for your loss.
Thank you.
All right, take names.
Yes, thank you.
Okay, this is in the matter of Gail Saylor, file 34249DD.
All right, the court's been asked to approve the 5th, 6th, and 7th annual accountings in this case. May I have the names of our participants, please? Anybody here on that one?
Bruce Saylor.
Okay, would you mind coming up to either the podium or one of the tables?
Sure.
That way we have you by a microphone at least.
Okay.
Michael McFarland, attorney guardian ad litem.
Thank you. Get my hands on that one. There it is. Okay, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Is all the information contained in your proposed accountings truthful, accurate, and complete to the best of your knowledge and information?
Yes.
Very good. Any comments you wish to make about your work in this case?
Not really.
All right, and how is Gail doing?
Real well. She does good.
All right. Mr. McFarland, did you have any questions or any comments?
No, I believe my database is a little bit slow this morning, Your Honor. I believe I signed a waiver and consent.
You did. And I have those in the file.
Then I have no questions.
Okay. Anything else that you wish to share with us this morning, Mr. Saylor?
I don't think so.
Okay, well, obviously the guardian ad litem has reviewed the accountings, as has the court. It will be the order of the court. The order will reflect the accountings are approved. You're welcome to also step across the hall for copies of this order before you leave today.
Okay.
Thank you again for your patience. Have a
Okay.
great day.
All right, thank you.
Okay.
Hey, sir, I believe, well, we're gonna go check, but the person we're going.
So I have a couple of other ones on my docket that I'm not sure are on yours.
I don't
Okay.
absolutely need it.
Okay.
Let's start with David Townley Perry. Do you have that one on yours? Perry? Yeah, here, I'll just give you my schedule. The two that aren't crossed out.
Oh, yep. David Perry, we did that.
Nope. I
No,
haven't.
we didn't.
We haven't called. I put that review. So whenever if you've got that one.
I do, I just.
Skipped it, I guess. Well, I kept up with you.
The reviewing attorney explained that receipts were necessary to confirm where funds had actually been spent. Without those records, the court could not fully complete its review.
Let me find it. This is in the matter of David Perry, file 52634.
All right, the court has been asked to approve the first annual accounting in this file. May I have the names of our participants?
Michael McFarland, attorney guardian ad litem.
Okay, Ms. Tamara Perry, can you hear me?
Yes, I can.
All right, may I have your name for the record, please?
Tamara Perry.
Thank you. Deputy Ames, would you swear Ms. Perry in for us, please?
I'm sorry, I couldn't hear that.
I'm gonna swear you in. Can you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, Ms. Perry, is all the information contained in this accounting truthful, accurate, and complete to the best of your knowledge and information?
Yes, it is.
Very good. I'm sure you may have had some communication from Mr. McFarland on some questions. Do you recall that?
Not from Mr. McFarland, no.
All right, I'll turn it over to you then, Mr. McFarland. It looks like,
Well, Your Honor, I sent a letter. Let me pull that up right now.
because I don't have a copy of your letter, which I usually do, but I don't have a waiver
Okay.
either.
Well, it says I sent this on November 18th and the address is Saginaw, Michigan. And I don't want to give the address on the air, but it's a the address begins with a K road.
Yeah.
And it says, "Dear Ms. Perry, I am the attorney guardian ad litem. Part of my duties are to review receipts. Unfortunately, there are no itemized receipts to support Schedule B categories. I need to review the attorney bill. These receipts should be submitted to the probate court clerk, which you will get back after the judge approves the accounting." That was November 18th. That was sent out, Your Honor, for the copy to the court.
Okay. So, Ms. Perry, were you able to hear that?
Yes, so he would like a copy of the attorney bill.
And the other receipts, if I might, I'm in charge of reviewing the receipts to make sure that the money spent actually went to where they're indicated.
Okay, so receipts for all expenses you need.
Correct. If I may address that, Your Honor.
You may.
If I might just have them in separate envelopes for each category, rather than just a whole box of receipts. You have itemized in Schedule B, so for each itemization, just an envelope for me to peruse.
Okay. Yes, I'm sorry, I never received that letter. It never came to me.
Things get lost in the mail. I understand.
It wasn't very long ago either. All right, so if I give you into January to get that around, is that enough time, Ms. Perry?
Oh, yes, that won't be a problem. Who do I send it to?
You'll have to send it over to the clerk's office, same place that you sent your proposed accounting. We just
Okay.
need all the supporting documents for that.
All right. And
And the
a
next-
copy of them is fine. It doesn't have to be originals.
I'm fine by that, Your Honor.
I think that's sufficient. Yep. Organized to save Mr. McFarland a little time.
Yes.
Very good. So the next time I have a 9 o'clock probate court call is Wednesday, January 15th. Would you be able to rejoin us by Zoom on the 15th of January at 9?
Double check my calendar.
9:30 is available too.
I'm guessing that's, the county's not utilizing the Martin Luther King holiday.
I don't see that on my.
Okay, I just know it's his official birthday, so I'm not sure what date it's scheduled for.
That's Monday, the 20th.
That's why, oh, okay, thank you.
Well,
So
this
you
is
said,
Wednesday, January 15th.
yes, that will
Wednesday,
be fine.
January 15th at 9. Okay. All right. I'll look forward to recalling the case at that time. Unless you have any
Okay, thank
questions,
you.
that's all for this morning. You're welcome.
All right, guys. This entire probate docket demonstrated one thing clearly. Paperwork, transparency, and accountability drive every decision inside probate court.
Your Honor, at this time, we are just asking, there is an emergency guardianship that has been in place since that initial hearing. Lillian continues to reside with Grandma, Miss Arnett, and we are just asking that the court support the full guardianship until the child has graduated from high school, which will be 1 year from now, or less than a year from now. She's entering her senior year. To my knowledge, I haven't received any formal objections to the petition. So again, the circumstances that were in place when the petition was filed still stay, and we are asking that parenting time be as Lillian agrees or wishes to see her mom. And then we are also asking that some type of support also be ordered in this case.
All right, Deputy Ames, would you swear in Ms. Freeze and actually the rest of our parties as well?
Remain seated, but raise your right hands, please. Thank you. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? And please give me a verbal answer.
I do. I do. All right, Ms. Freeze, I have your report. Would you like to confirm that on record and then add any comments you might have?
Yeah, so I completed a investigation with Mrs. Arnett. And I do want to put it on the record. My report says her daughter Rachel, but it's Michelle. I don't know. So I apologize that I did spell her name wrong. But I did complete a home visit. The home is appropriate. I spoke with Lillian. I mean, she wants to stay with her grandma, so I am in support. Everyone's appropriate. We ran clearances, CPS history, everything came back clear. So I am recommending that she stay with her grandmother.
Thank you.
You're welcome.
Okay, Ms. Jesusa Arnett, do you have any comments today?
I do not, Your Honor.
Right. Ms. Ashley Winans, do you have any objection to the request for guardianship?
So I had actually spoken to Jesus's attorney and said that I would be wanting to come to some sort of agreement with this. And she had told me that they were going to try to arrange a conference call with me to discuss this beforehand, and I never heard back from her. But I do have some concerns. I'm not objecting to Jesusa having guardianship of my daughter. You know, I made the choice that my daughter could live with her grandma, and I had no intentions of changing that. But I would like to be able to participate in major medical decisions for my daughter. I also would like my daughter to have to participate in counseling. There was an agreement between everyone who's involved with my daughter's life, her grandma, her aunt, her uncle, her dad's girlfriend or ex-girlfriend, that and my daughter, that she would start therapy because she really, really desperately needs it. And therapy was arranged, and my Jesusa did not send my daughter to therapy. And so I'm very concerned about that. My daughter was very excited for a couple weeks before going to therapy. I talked to her several times. She was very open to starting therapy. And then the day of her appointment, I received messages from both Jesusa and my daughter that she was not going to be attending her therapy appointment. So that's one of my major concerns. And just that I want to be able to participate in major medical decisions for my daughter. Jesusa, I feel, especially with this therapy situation, has not made the best choices for the medical, making medical appointments, her not taking my daughter, making eye appointments. They didn't show up for the eye appointment. So I'm just very concerned that my daughter is not going to receive all of the medical care that she needs. And then lastly, I'm also concerned, Jesus, my daughter gets survivor benefits through her father's passing away. And I don't think that Jesusa has made the best financial decisions with my daughter's money. And I'm also concerned about that. So, in fact, my daughter's money paid for her attorney for this hearing. And I don't think that's appropriate that she's using, I'm sure, thousands of dollars to retain an attorney to come to court, especially when she didn't ask me, hey, I need guardianship of Lily. I want to be able to make medical decisions for her. I want to be able to do this, do that. So and I reached out to her attorney. I told her I was more than willing to come to an agreement. I didn't want to have to come to a hearing. And so here we are using thousands of dollars of my daughter's money to pay for an attorney to be here today. And I don't think that that's appropriate. I think that she should have to pay my daughter back.
Ms. Lillian Arnett, do you wish to have Jesusa Arnett in the role actively of parent? And that would include you staying where you are, obviously, but it would continue to allow Jesusa Arnett to have control over where you are, what your medical care is, what happens with those funds, all of those things. Do you understand that? Is that what you wish to do? Well, I would be inclined to send all parties to mediation, and the court can facilitate the cost of that on some of the issues that were raised by Ms. Winans, as well as the issue potentially of support to consider that benefit as well, and parenting time for purposes of producing a placement plan. So do you have any objection to that, Ms. Underwood?
With respect to,
I'll make a ruling on the guardianship today. I'll give you an opportunity to ask any questions of any other witnesses. And then if I grant the guardianship, which it does sound like for the most part, Ms. Winans doesn't have any objections, nor has she contested the factual basis of the petition. But there are some issues that could be worked out, in my opinion, on mediation.
I'm sorry, I just
Ms. Winans, I can't allow you to interrupt.
I'm sorry.
So that's what I'm thinking, but I'm happy to listen to any further witness testimony or whatever else you might want to present.
my client would like to,
I'd like to respond. Concerns. That's
I mean, I can call my client. Again, I'm not sure. Again, there was talks of having a meeting with Ms. Winans. However, after speaking with my client, I don't know that there.
Here's where the legal analysis became critical. The judge reviewed the statutory requirements for guardianship and compared them against the facts presented.
Been any productivity that would have occurred there, and because she was not necessarily opposed to Lillian staying where she is, again, I felt it would be best to just have a ruling on the guardianship. As far as support and other issues regarding medical care, again, if there's a court order that says, Your Honor, that Jesus is responsible for setting up and participating in medical appointments for the child, she'll do so. Lillian's also 17, so she's capable of getting herself to appointments, and she's at the age of she's able to participate in those. Typically with guardianships, again, I know there isn't always a child support component, so whether that can just be remanded to the appropriate friend of the court or wherever that would go for support, I would be in agreement with that. I just am not sure how productive a mediation would be in these circumstances, because Ms. Arnett and Ms. Winans do not see eye to eye really at all.
But Ms. Winans does at least trust my client enough to be able to put her child in Ms. Arnett's care while she lives in another county. So at this point, I think the most productive or expedient matter would probably be for you to make your ruling on the guardianship, and then whatever the traditional or standard way to determine support would be my recommendation or my position on that.
Ms. Williams, did you wish to say anything else?
Yes, please. So, with all of that being said, it's not necessarily that I trust Lusa. It's that I made the decision to allow my daughter to stay there because I was moving. She really wanted to stay in Lenawee County because she wanted to continue to attend school there. She didn't want to leave all of her friends. We've had quite a few issues with attendance when she's been with Jesusa. With her skipping school, Jesusa was aware that she was skipping school.
So Ms. Winans, here's the bottom line for me today. I need to know whether or not you are objecting to the request for guardianship. All of the rest of this, I'm gonna send all of you to mediation on, and whatever you can't agree on, then you're gonna come back to me and I'm gonna make those decisions. But for purposes of the issue Ms. Underwood raised and the issues that you are raising, those need to be considered in the context of the placement plan. So the placement plan identifies why the child is in the guardianship, what the barriers are between, as far as reuniting the child and the parent, and visitation and support. And all of you need to sit down in a context outside of this courtroom and air those issues in an organized, civilized manner, which mediation will afford you the opportunity to do that. If an agreement cannot be reached on some of those things, then I would expect you to come back and I'll make a ruling on what the issues are, on what the visitation is going to be, and on any support. Enforcement is done on a civil basis, unless there are, sometimes the prosecutor's office is triggered to pursue that because benefits have been requested from the state of Michigan. But as it relates to guardianship, the front of the court typically does not get involved with support. That will, however, be something that our mediator will be able to discuss and allow you to discuss, especially considering that there are benefits already in place.
Is it?
So it sounds to me like you have made the, Ms. Winans, you, I haven't heard anything that would indicate to me that you intend to take your daughter back into your care. Is that the case?
Not necessarily. I'm asking, is it possible to do guardianship where she has partial guardianship and I also have guardianship? Because I don't think that this is a situation where it's appropriate for her to have the only rights to make medical decisions for my daughter. That's not appropriate.
At this juncture, the request made of the court is to consider a full guardianship, not a limited guardianship. A limited guardianship would be one where you are consenting to.
Then yes, I object.
All right. Any further presentation, Ms. Underwood, on the underlying request? No, you're on. Very good. All right, the court finds all interested parties were given notice for purposes of today's hearing on guardianship. I reviewed the file. I was present for the initial hearing wherein it was necessary to grant emergency guardianship power to Ms. Jesusa Arnett for Lillian in order to allow her to get medical care, enroll in school, and all of those issues that she needed Jesusa Arnett to tackle because she was not living with a parent at the time. She was in fact living with Ms. Jesusa Arnett when the petition was filed. She continues to reside with Jesusa Arnett at the time of this hearing on the request for full guardianship. And I do hear and honor the mother's objections on these issues. However, at the end of the day, I have to simply evaluate whether or not the components of the statute have been met. And in this case, I do find they have been met. I have a situation where unfortunately Lillian's father has passed away and her mother has allowed her to reside with Jesusa Arnett without providing her the legal authority for the care and maintenance of the child. And she was not residing with the parent when the petition was filed, as I've already articulated. I find further, as a result of what I've heard, my familiarity with the file, as well as the investigation conducted by the department, that the welfare of Lillian Rosa Arnett is served by the appointment of this guardianship. I hear your concerns, Ms. Winans, and that is why I am sending the case to mediation for purposes of the placement plan. I know customarily, not every court requires a placement plan in full guardianships, but I do. That is so that in the event that mom comes back and wants this child back under her care, I have a plan to look at whether or not she's succeeded in visiting when she said she was going to visit, in participating as she says she wants to participate. I want to look at what that plan is. And that way, if there's a request for termination of guardianship in the future, I can make an informed decision on what the plan was and whether or not it was followed. Will be the order of the court. The petition is granted. Jesus Arnett is appointed the full guardian of Lillian. It is a regular appointment requiring annual reports. And again, the parties will be sent to mediation regarding period of time, child support, and the rest of the components of the placement plan. But as of today, I am granting the request to allow Lisa Arnett to serve as guardian for Lillian because as I see it, that's necessary under the circumstances for the reasons that I've mentioned. The court will submit to you, Ms. Winans, the information to contact the mediator. We are going to pay him. We have a certain amount of funds set aside in order to do that, but you will be required to cooperate with mediation. And I think they can maybe do that by Zoom, but I'll leave that to you and the mediator to organize. And I wish you the best of luck. That's all for today.
Will I receive that from the court or will that be coming from her attorney?
That will be coming from the court. The information on the mediation will be coming from the court. Are you still, let's see. I think, have you received mail from the court, notices and all that?
So everything has come from Jesus's attorney, and except for a note, I never received a notice for the emergency hearing. My daughter was told that the attorney emailed me. I never received an email from the attorney. I searched both of my emails. So I just want to make
I'm gonna, Ms. Winans, all I need to know is if your address is correct. So I'm gonna.
As the hearing closed, the judge stressed that mediation would address parenting time, support, communication, and future expectations. All right, guys, the message was clear. Guardianship would remain in place, but the family's unresolved conflicts were far from over.